Making sure you have correctly identified the employment status of the people you have working in your business has never been more important, as the broad programme of measures the government is introducing through the Good Work Plan are all centred around the rights of the individual, which in turn hinge upon their employment status. Now, there are lots of misconceptions around employment status. Perhaps the greatest misconception is that the nature of the relationship is something which the parties can agree between themselves. This is not the case. If a tribunal were to look at classifying the employment status of a working arrangement, they would not start off from the point of the view of what the parties had agreed it was. They would look at all aspects of that working relationship and then identify what they felt was the most accurate status. Another misconception business owners can have is that if they agree to give an individual a certain employment status within their business, that can protect them in the future from the individual stating that actually they were something else. We often come across cases of this where when we first speak with clients, we find that they've got a lot of individuals in the business who do effectively the same job, some of which are on payroll and others are working off payroll as self-employed. And when we inquire as to how that arrangement has come about, we often find that that is because that is the way those individuals preferred it to be. But unfortunately, that will not protect the employer from those individuals later on arguing that in fact they are employees if it suits their purposes in the future, for example, at a time when the business no longer needs their services. Another very common misconception is that if an individual is treated as self-employed for tax purposes, then it will automatically follow that they will be self-employed for employment rights purposes. This is incorrect, and there are two main reasons why this is the case. First of all, the test for employment status in tax is different from the employment status in employment rights. The tax status test is based on a binary choice. You can either be employed or self-employed, whereas for employment rights purposes, you can be an employee with a full range of rights, or self-employed, or you can fall in between and be classified as a worker. Secondly, the fact that an individual has been treated as self-employed for tax purposes, and even though that may have been scrutinised by HMRC, will not prevent a tribunal from reviewing the situation and looking at all the factors to determine what they feel is the most appropriate classification for the working relationship. Businesses often feel that if they give a contract to an individual stating that they are self-employed, then as long as the contract documentation looks to support that status, they'll be fine. Unfortunately, that's not the case. Certainly, if you get your documentation wrong, you can put yourself in a very, very difficult position. But just because the documentation suggests one status, this will not protect the business if in reality the true working relationship looks very different. And this is very commonly the case with a right to substitute. Given that in self-employed relationships there is no requirement for providing personal service, it is very common for business owners to put in a right of substitution to show that actually this is a genuine self-employed relationship. But if in the practical realities of the situation this is never relied upon, or indeed is very severely restricted, it is much less likely that this will be viewed as a true self-employed relationship. Finally, a business can do everything in their power to get their documentation right, to review what the true nature of the relationship is going to be, to make sure that the individual is happy with that relationship, and ascertain the true nature of the employment status as correctly as possible, and then feel that they have got their work done. Unfortunately, these situations must always be kept under review, because a relationship can start out as one thing and then over time move into a different relationship very easily without the parties being aware of it. So my advice would be to always keep the situation under review.